to this media conference. The purpose of calling this media conference is to announce that today at 3 p.m., the Minister of Labor, pursuant to the provisions of Section 65 of the Industrial Relations Act, filed an ex parte application with the Industrial Court against the Trinidad and Tobago Unified Teachers Association. And at 5 p.m. today, the Industrial Court granted an ex parte order. I've made copies for all of you, and my apologies for the late start, but the court wanted to be very careful in the drafting of the order which it has granted. So I literally had that order scanned through to me 2 minutes ago, and then I came down to speak with you all. The application was made by the Minister of Labor in the context of ongoing illegal action by the Trinidad and Tobago Unified Teachers Association and the members of that association, the members of the teaching service of Trinidad and Tobago. And the government became very concerned to make an application to the court to bring an end to this illegal action in the national interest. The application is made pursuant to Section 65 of the Industrial Relations Act, which reads that where industrial action is threatened or taken, whether in conformity with this act or otherwise, and the minister, that is to say the Minister of Labor, considers that the national interest is threatened or affected thereby, he may make application to the court, that is to say the Industrial Court, ex parte, meaning without the other side being present, for an injunction restraining the parties from commencing or from continuing the action, and the court may make such order thereon as it considers fit, having regard to the national interest. The application, which was filed with the Industrial Court this afternoon at 3 o'clock, in the wisdom of the government of Trinidad and Tobago, was served on the union so that they were aware of the fact that the application was being made. And in fact, I'm advised that one of the attorneys representing the union had a conversation with Mr. Russell Martineau, who represents the Minister of Labor, but there was no appearance on the part of attorneys for the union, so the application proceeded ex parte, that is to say, in the absence of any representative of the defendant respondent to the application. The illegal industrial action which was being taken started on the 5th of September, the first day of the opening of primary and secondary schools in the new term in Trinidad and Tobago. And the records show that upwards of 50%, sometimes as high as 70% of primary school teachers and secondary school teachers have stayed away from school as a result of being called on by their union to, quote unquote, rest and reflect. That action is threatened to continue tomorrow, the 26th, which is the first day of school for the coming week. And it is against the background of that threatened action that the government took the decision to approach the court. So that today we were able to receive an order of the court, but before I spell out the terms of that order, I will just want to mention briefly that the illegality of the action that is being undertaken by tutor and the teachers who are members of tutor is because of the simple fact that under Section 69(1)(d) of the Industrial Relations Act, the teaching service is an essential service. The teaching service is not permitted to take industrial action, whether by way of resting and reflecting and amounting to not turning out to work. And that was spelled out in the affidavit of the Minister of Labor in the several paragraphs of that affidavit. There is actually an old case, the locus classicus, in this jurisdiction, a 1997 case, which spells out very, very clearly the jurisdiction of the industrial court in exactly a situation such as this, where a union, in that case, 1997, was the Trinidad and Tobago Unified Teachers Association, and the application was made by the Minister of Labor then, Mr. McShine, and the industrial court, in the person of the then vice president, who went on to become its president, Mr. Addison Khan, produced a very learned and compelling judgment, which we in the area of industrial relations practitioners refer to as one of the locus classicus cases out of that jurisdiction. I mention that simply to make the point that there could be no doubt on the part of the Unified Teachers Association tutor, or in fact those advised in the union, that the action that they have undertaken over the last couple of weeks since the start of the new school term is illegal. The case law is there. It is a case that was actually produced as a result of action of tutor back in 1997. And the industrial court was well aware of that case. We put several cases before them today. Mr. Russell Martineau, who I thank, and his team, and you will see the names of the team members from the order that I will distribute. That order reads today, and may I just say that the court which sat today at 5 o'clock was Her Honor the President, Mrs. Deborah Thomas Felix, His Honor the Vice President, Mr. Herbert Sovereign, His Honor the Chairperson of the Essential Services Division, Mr. Lawrence Achong, and His Honor Mr. Gregory Rousseau. 4 judges of the Industrial Court sat today at 5 p.m. to hear the application. And the order reads as follows. Upon an ex parte application for injunctive relief this day made unto this honorable court by counsel for party number 1, that is to say the Minister of Labor. Upon reading the notice of application dated and filed herein on the 25th of September, and the affidavit of the Honorable Minister of Labor, the Honorable Mr. Stephen McClashy, sworn and filed today, the 25th of September, the court deems the contents therein to be serious and warrants the urgent intervention of this honorable court. It is hereby ordered, 1, an interim order of an ex parte injunction is hereby granted. It is ordered that party number 2, the Trinidad and Tobago Unified Teachers Association, 1, whether by its president, executive, and or members of the teaching service, or otherwise howsoever, are hereby restrained from commencing and or continuing and or taking industrial action, including, quote, resting and reflecting, unquote, on the 26th of September, 2022. 2, whether by its president, executive, and or members of the teaching service, or otherwise whatsoever, is enjoined, party number 2 is enjoined from commencing and or continuing and or taking industrial action. It is also ordered that party number 2, that is to say tutor, is directed forthwith through its president and executive to instruct and or direct its members of the teaching service to report for duty on the 26th of September 2022 and continuing as they are required to do in the normal course of their employment. It is further ordered that leave is granted to party number 1, that is to say the Minister of Labor, to serve a copy of the notice of application and affidavit in support, together with a copy of this order on party number 2, the union. That this order of an injunction be published in the Trinidad and Tobago Gazette and once in 2 daily newspapers circulating in Trinidad and Tobago, and that this injunction shall continue until further ordered. And that Injunction is returnable, meaning that the union is given an opportunity to return to the industrial court on the 24th of November at the hour of 1:30 o'clock in the afternoon to contest or otherwise address the terms of this order which has been granted. And very importantly, there is affixed to this order and forming part of this order what is referred to as the penal clause, which is written in red so as to highlight its significance. The penal clause of an injunction order is that clause which cautions and warns parties against whom such an order is addressed of the consequences of failing to obey the order. And may I say that the service of this order is carefully thought through in the Industrial Relations Act, Section 65, subsection 3, because that act makes it clear that an order made by the court under subsection 1 shall be published in the Gazette and in at least one daily newspaper circulated in Trinidad and Tobago, and the publication shall be deemed to be service of notice thereof on all parties to the dispute, including all workers engaged in the industrial action, whether threatened or taking place. We have had today on standby the very hard-working staff of the government printry who worked for 2 years through the pandemic to issue the legal notices that have allowed us to survive the pandemic. We have had them on standby, and as I speak to you, the Gazette is being printed so that by the time this media conference is over, and certainly not too long after that, the Gazette shall have been published, and that publication of the Gazette will mean that the order that I've just read out is deemed to have been served on the union and on every member of the teaching service of Trinidad and Tobago who are warned by the court that they must turn up for work tomorrow, 26th of September. You may ask the question, what other penalties exist in respect of an order of this nature? And if you were to ask that question, I would tell you that under Section 63 of the Industrial Relations Act, subsection 1B, a trade union taking such action when the case is finally heard, not at this stage, in what will be termed an industrial relations offense. A trade union taking such action is guilty of an industrial relations offense, and in addition to any other penalty under subsection 2, the court may order the cancellation of its certificate of recognition. So that is one of the consequences that tutor will have to consider addressing when it comes to court on the 24th of November to defend what is going to evolve into a complaint by the Minister of Labour of an industrial relations offense being committed by the registered majority union tutor. Subsection 1C prescribes, subject to other sections of the Act, that where a worker takes part in such action, the employer may treat the action as a fundamental breach of contract going to the root of the contract of employment of the worker. Lawyers will know that that means that the employer would have the entitlement, subject of course to law, to treat the conduct of the workers who disobey this order as their own election to have terminated their contracts of service. Section 63(2) also says, in the case of a trade union, a person guilty of an industrial relations offense under this section is liable, in the case of a trade union, to a fine of $10,000. Section 67(5)(a) tells us a trade union or other organization, the holder of an office in the trade union or other organization, or any other person who calls for or causes industrial action to be taken in an essential service or induces or persuades any worker in that service to take such action is liable on summary conviction, A, in the case of a trade union, to a fine of $20,000, and the board, that is to say the Recognition and Certification Board, may cancel the certificate of recognition under Part 3 of that trade union. Section 67(5)(b) In the case of the holder of an office of a trade union, it goes on, and in the case of an individual who is not the holder, it goes on. So the Act was very carefully crafted to provide for the fact that in an essential service, members of that essential service are not allowed to take industrial action, and there are very serious consequences that follow from such illegal action being taken by either the union or its members. So, without belaboring the point, ladies and gentlemen, as a consequence of this order, it is my confident expectation that law-abiding citizens of Trinidad and Tobago, including teachers, will turn out for work tomorrow, and parents of those students can expect to send their children to school, and the schools will be properly staffed. Thank you very much. I'm happy to take a few questions.
PG Gentleman from the UC, how would the court differentiate a genuine sick leave action tomorrow from answering the call from tutor to rest and reflect?
Well, I'd answer it in this way, Mr. Levin. Good question. First of all, whoever is going to rely on a sick leave certificate is going to have to produce that sick leave certificate in court to the employer. And how would the court deal with it? That will be for the court to determine. But one of the cautions that I would certainly sound is the doctors who are issuing the certificates will have to be aware of the terms of this order as well, because genuine sick leave certificates will be respected, not otherwise.
From my understanding, sick leave was only needed after a certain number of days, so these teachers could call in sick tomorrow. What is to stop them from doing that?
Well, let's leave it to the court to determine that. I don't want to prejudge how the court is going to deal with such application or defense as may be put forward by the union. I wouldn't want to speculate on that. I have every confidence in the Industrial Court of Trinidad and
Welcome to Reset Expectations. I am Alicia Cabrera, Executive Manager of Marketing and Loyalty. We at Caribbean Airlines are pleased to announce the redefined Jetpack courier service, offering you, our valued customers, a new Skybox experience with remarkable benefits. The upgraded Jetpack service is now door-to-door. As such, you can shop online and have your packages of £50 or less delivered directly to your home or business.
At Caribbean Airlines, we are always looking for ways to enhance our products and services to our customers. Today, we are excited to launch our Jetpack Skybox courier service in Trinidad and Tobago. Our vision for Jetpack is to better connect the region and to efficiently and affordably connect the region to the world. The process to use our service is quite simple. Step 1, register for the service via our website, jetpack.caribbean-airlines.com, or via our mobile app, where you will receive a US address and account number. Step 2, shop online and have your packages delivered to the US address provided. And step 3, in a matter of days, your package will be delivered to your door, or you can collect at your convenience at our pickup locations. We start with 2 locations in Trinidad, one at the Parkade in Port of Spain, and the other at our cargo facility in Piarco. Tobago starts with a delivery-only option. In addition to convenience, speed, and our affordability, there are many benefits to utilizing our service. These include being part of the CAL ecosystem, as you can earn miles when you ship, access discounts on future packages, track your items in real time, and earn free flights from time to time.
Thank you, Markland, and the hard-working team at our cargo department, another core group within the Caribbean Airlines family.
Caribbean Airlines CEO Garvin Madeira gave a commitment at the start of the year to reset expectations, and the airline continues to deliver, offering customers greater value for products and services, as well as innovative features and services which will take Caribbean Airlines into new territory.
Expedited shipping is a critical need for many organizations and individuals. All the more so since the pandemic had such a fundamental impact on the global and local economy. We have offered an airport-to-airport